Okay, we'd like to welcome everyone to TCN's compliance webinar today. We are very grateful and excited to have our special guest Eric Allen with us today. He brings a wealth of knowledge and experience to you regarding the topic of compliance. I've had the opportunity to discuss with him the most common questions that we hear from our clients on a regular basis, and he has some great arguments and insights into ways to help you continue to be profitable as a business while at the same time mitigating your risk. And I think that's kind of what everyone wants to know. How can you keep doing what you need to be doing but mitigate your risk? We felt that his experience and thoughts on the subject would be very beneficial to our clients, and we hope that you will all come away from this next hour feeling like your questions have been answered and you have a more clear path to success. Here at TCN, we continue to daily monitor what is happening with the various discussions, the lawsuits, and legal opinions that are going on regarding the multiple areas of regulatory oversight for your industry. We put great efforts towards designing and releasing many tools and features aimed at helping you in your compliance efforts. We currently have many easy to implement rules and settings, but I'm also excited to announce that we are in the final stages of releasing part 2 in our compliance suite that will add even more options, giving you additional abilities to set very specific rules by state and even by account number, and many other compliance suites, which we'll be talking about later when that's ready to be released. I know you'll be very excited to learn about those capabilities. And of course, we previously released our manual-only platform, a separate platform to be able to dial those cell phones, and along with our manually approved calling enhancement that helps you maintain production while focusing on compliance. You're just not going to be able to find a more flexible, easy to use system than what you find here at TCN. At this point, I'm very excited to be turning the time over to Mr. Eric Allen. He's a compliance attorney. One of the things is he's actually worked in the call center industry for many years and is now the managing attorney at Allen Mitchell and Allen Law Firm. Like I've mentioned, I've had quite a bit of time to talk to him, and he's got some very, very interesting things to say about what you can do to help mitigate your risk. At the end of the presentation, we'll try to leave as much time as possible for questions. You can either send me an email at bryce.payne@tcnp3.com, or you can enter your questions in the questions portal on your webinar tool. We appreciate you taking the time to join us today and look forward to answering any questions you might have. At this time, I'd like to turn the time over to Mr. Allen.
Bryce, thank you. A great pleasure, always. Our firm is based out of Salt Lake City, Utah. We're a law firm for call centers. We do represent a lot of telemarketers, but also floors that specialize in debt collection, customer service, and other non-marketing calls. We do primarily the compliance side, but we also defend call centers, sellers, dialer vendors, lead generators when they receive demand letters, lawsuits, frivolous government investigations and fines, etc. So our agenda, and I've got about 40 slides, but I'm going to move really fast, maybe about 30-40 seconds a slide. We'll leave plenty of time for Q&A afterward. Our agenda is this: quick overview on the federal dialer rules and the TCPA specifically. Then an update on the July 10, 2015 changes. This is this crazy order that came out this year. Caught a lot of us off guard, and you know, some negative in it, but also some silver linings and lots of solutions, obviously. Third, we'll talk about how you obtain consent to auto dial cell phones and what type of consent you need for the various different types of calls. You may need a certain type of consent for a collections call that's different than the type of consent you would need for some sort of newspaper renewal effort, for example. Next, I'll give you some final recommendations, and of course, we'll be sure to save hopefully at least 20 or so minutes for Q&A. Who is watching you? Why does the TCPA matter? Why do these rules matter? Who is policing call centers? Today we're going to talk about the FCC. Their big law is the TCPA, the Telephone Consumer Protection Act. But don't forget there are other agencies that are watching as well. The Federal Trade Commission doesn't really have jurisdiction over debt collectors and has jurisdiction over very few flavors of non-telemarketing, but still important and regulates some calls. You have the relatively new, huge, and well-funded CFPB, the Consumer Financial Protection Bureau. You, of course, have the U.S. AG's office. You have state AGs and divisions of consumer protection. Also, don't forget these non-governmental sort of watchdog groups. This is what I would call the neighborhood watch of call center compliance. Agencies like the Better Business Bureau, not a government agency, but they observe and report. Also, all these agencies share complaint data through their Consumer Sentinel system. If you have errors, it's pretty hard to hide them these days. And of course, private litigators, plaintiffs that want to sue you, make money taking advantage of some of these laws. So the TCPA passed in '91, but since then the FCC has come out with all these changes, regulations, orders, rulings, fleshing out, expanding, interpreting the plain language of the TCPA. Whether they are authorized to do some of the things they have done or not is up for debate, but we have all these new rules that are not actually in the statute itself, but are in the FCC's regulations and orders. It has a lot of rules. A lot of these rules apply to telemarketers only, but some of them, in particular, the auto dialer and cell phone rules apply to non-marketers like collection agencies, customer service floors, agencies that are doing things other than taking cards and soliciting over the phone. The FCC and its TCPA govern calls, texts, faxes, and as I mentioned, there are more rules for marketing. The TCPA contains this private right of action, meaning a consumer gets to, rather than just complain to the FCC or their AG or whatever, they get to sue you directly. They can walk into their local district court or small claims court or big bad federal trial court and sue you for damages, even if they suffered no harm. And the lawsuits are on the rise. Here is the TCPA's relatively nasty dialer ban that we're going to focus on today. It is unlawful to make calls using an auto dialer or pre-recorded messages, basically I'm paraphrasing, to any number assigned to a cell phone or any other service for which the called party is charged for the call. So, unless you've got consent or some other exemption like an emergency, you cannot auto dial a cell phone or any other device where they're charged for the call. Kind of interesting. There was a case last year where someone calling a VoIP phone where the called party was charged per call was actually held liable as if the VoIP phone were a cell phone. Kind of a rare case, but kind of interesting. Why does it matter in terms of your exposure? Well, these private plaintiffs get to sue you for up to $1,500 per call. And actually, it's per individual violation, and you might have multiple violations per call. For example, you might auto dial without consent, plus maybe you have a disclosure problem, and you failed to have an opt-out function, etc. And boom, 3 violations in 1 call. That stacks up pretty quick. Also, if you generate a lot of consumer complaints, the FCC can come in and investigate you and fine you up to $16,000 per call or violation. State fines, we've got a little chart for you at telemarketingfines.com if you're interested. Also, injunctions, local government enforcement actions. You may have to disclose it on future applications for professional licensing or financing, etc. And in rare cases, criminal charges if you actually violate a court order or there's some additional fraud component to your call center violation. What is an auto dialer? This was important before these new July 10 changes, and even more important now. The feds use this term ATDS, Automatic Telephone Dialing System. When they say auto dialer or robocall, they very often are sloppy about the way they use that. They use them sometimes in conflicting and inconsistent ways. They don't always mean the same things you and I think of when we hear auto dialer or robocall. But when they say auto dialer or ATDS, they mean any system which can store or produce numbers randomly or sequentially and dial them, or any other system which just generally has the capacity to dial without human intervention. And then just a few months ago on July 10, the FCC expanded that to include some interesting future potential capacity type triggers. So the original TCPA, in the law itself, it just talks about this random sequential dialing. That's really all it talked about. You know, the very first robocall systems, you know, were hardware, and they would just call the phone book or generate numbers at random and call them one in sequence, et cetera. But then we have this, you know, predictive dialers came about, where they're calling from a list. They're not doing random sequential. And boom, the FCC needs to figure out how to capture that. So rather than going back to Congress and having Congress amend the TCPA, they just create some additional regulations about really predictive dialers, but they captured more than they were hoping. So now the rule is any other system which could dial without human intervention. And what does that mean? Is that just now, present capacity? Well, no. On July 10, the FCC clarified that if the system, you know, if you could flip a switch or quickly upgrade it to auto dial, then even though it can't auto dial now, maybe it's still an auto dialer because it could be quickly turned into an auto dialer. We'll talk about exposure there and some solutions. And of course, a text is treated essentially the same as a call under the TCPA. Okay, I know most on this call are either debt collectors or non-telemarketing outfits, but I am going to say a few things about marketing, because there are some things that, even though it's not required for anyone but a marketer, it may be a best practice still for a debt collector. Also, it's important that we know the difference between marketing and non-marketing, so you don't accidentally cross the line. Seemingly innocent customer service or confirmation message crosses the line and becomes telemarketing if there's any promotional purpose or component added to it or underlying it. So for marketers may not make solicitations over the phone or via text using an auto dialer to a cell phone without prior express written consent. That was the kind of October 2013 compliance, so-called compliance cliff that we dealt with a couple of years ago. A written consent is required for marketers who use auto dialers to call cell phones. That's not the case for debt collectors and non-marketers, as we'll see in a moment. Also, again, auto dialers include all sorts of platforms, those that do power, predictive, random sequential, etc., or could otherwise dial without call-by-call human intervention if told to do so. Additionally, if marketers want to use pre-recorded messages or artificial voices, they need written consent, whether it's a landline or a cell phone. And of course, marketers are subject to a host of other behavioral rules that you may not be subject to. Certain marketing disclosures, the 3% abandonment rate, the call abandoned message, automated opt-out functionality, etc. Generally not the case for non-marketing call centers. Also, remember, states have their own dialer rules sometimes that go above and beyond the TCPA. They may have licensing requirements, bonding, etc. Okay, this is what you care about, most of you. What are the dialer rules for debt collection and other non-marketing call centers? Well, I broke this down into kind of landlines versus cell phones. Non-marketing calls from an auto dialer or pre-recorded or artificial voices to landlines are fine. You don't need consent unless you've got some weird local or state issue. Under the federal rules, you're fine. You get to use your predictive dialer or any dialer, including the use of pre-recorded messages, or what I'd call a robocall, to a landline, as long as it's not telemarketing, as long as there's no promotional purpose or component. You don't need consent. Where you need consent is for cell phones. This is the sticky issue for debt collectors, for customer service, confirmation, informational, transactional, so-called type campaigns. For calling a wireless phone, these are the rules. For non-marketing auto-dialed calls, you're going to be okay to a cell phone so long as, so long as you've got consent, obviously, but more importantly, so long as the consumer, even if you don't have like written consent or anything, so long as the consumer or debtor provided you with their wireless number directly to you in the normal course of business without conditions and haven't opted out. This is really interesting because the TCPA says even for non-marketing auto-dialed calls to cell phones, you need quote-unquote express consent. But here the FCC is giving us kind of this implied express consent. That's kind of an oxymoron. How can implied consent be express? It's kind of the opposite, but this is one great thing the FCC gave us a few years ago. A non-marketer, like a debt collector, gets to auto-dial a cell phone. If the consumer or debtor gave that creditor or collector that cell phone number in the normal course of business and hasn't opted out or had the number reassigned. So let's break this down, though, because I know some collection agencies on the phone may own the debt and they're the original creditor, but probably more are third-party collectors calling on behalf of or as the agent of the original creditor, and then another subset may be debt buyers, floors who bought the debt and they're calling on their own name, on their own behalf as the new debt owner. Well, this consent rule kind of changes depending upon which category you fall into, or I should say the consent may or may not transfer. Of course, the original creditor who got the cell phone number from the debtor gets that implied consent if it meets the factors above. But the third-party debt collector who's calling kind of on consignment, as they say, also normally gets that same implied consent. They stand in the shoes of the original creditor in this regard, and that's the phrase that some courts have used. They enjoy that same implied consent based on the previous provision of the number. Again, so long as it was collected without any conditions, meaning, oh, we're only going to use this for record keeping. We're not going to call you. If you said that, then no, you don't get implied consent to call. But if they gave you the number without conditions and haven't opted out or changed their number, you get to call them as if they gave you permission to call. What about a debt buyer? What if you're in that last category where you bought the debt? It wasn't that the debtor gave you their cell phone number. You just happened to buy some accounts from the underlying creditor, or maybe from someone else who bought it from someone else, and you're way down the line. Well, there's a good chance you may not have this implied consent. The only way a debt buyer who now owns the debt and calls only on their own behalf gets that implied consent is if they too were given that cell phone number in the normal course of business, or if all the paperwork was very, very, very careful, meaning when the phone number was collected from the debtor, it was clear that the creditor gets the right to assign that right to contact. And then in the transaction between the creditor one and the new debt buyer, the documents were clear to convey that consent to contact, et cetera. So it's a lot tougher for someone who bought the actual debt and owns it and isn't working on consignment to take a transfer of that implied consent. But it is possible if you're careful. Finally, watch out for other behavioral rules in the TCPA and of course the FDCPA, privacy rules, disclosures, honoring a written demand to cease contact, et cetera. Okay, so I know most or everybody on this call thinks they're not doing telemarketing, and you may be right, but there are probably some of you that have gotten close to the line or maybe crossed it for some of your messages. Be very, very careful. Telemarketing is defined broadly, and if you become a telemarketer, then all of a sudden you're subject to all these other behavioral rules. You need written consent, not just this implied express consent. You may need licensing, bonding, et cetera. So telemarketing is essentially a telephone call for the purpose of encouraging a purchase. And it's even more broad in the FTC's TSR, telemarketing sales rule, which means it's any call that's part of a broader plan where the goal is to induce a sale. So even if you're just doing a survey and you intend to use those results or that data to make solicitations later, the call might be telemarketing. So be real careful, don't cross the line. What's not telemarketing? Pure collections calls. Informational calls that have no underlying promotional purpose. Most reminders, notifications, delivery confirmations, etc. Just be careful, don't cross the line. If your message becomes dual purpose and you throw in some sort of promotional advertising statement, or if the underlying goal isn't really customer service, it's really part of a marketing campaign, then you're telemarketing. A few quick examples. Hi, this is a reminder that your subscription expires at the end of the month and you can call us at blah, 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 blah to renew. Well, that's marketing. You're trying to renew, re-up. Next, your credit card on file is expired or was declined. Please call blank to update your card information. I do not believe that's marketing. That's more just account management. Third, your order was shipped on X date and you should receive it within 3 to 5 days. That's just kind of a delivery confirmation. It's not marketing. You should have received your first delivery yesterday. Thank you for being a subscriber of ABC Inc., the greatest newspaper on earth. Well, it started out not being marketing, but they crossed the line when they threw in some promotional advertising content. And finally, hi Scott, I'm calling about your overdue account with ABC Inc., of course, but while I have you, could I also talk to you about maybe um, seeing if you want to reopen your gym membership? That's a dual purpose call. So it's marketing. There's a marketing component, a promotional component. And then you're subject to rules that telemarketers have to play by. So be careful not to cross the line. Okay, other exemptions. Well, for telemarketing, you would need written consent to call a cell phone. Express consent, which again can be implied for non-marketing robocalls and tax-exempt nonprofits. Certain HIPAA, healthcare-related calls. I don't think anyone on here really deals with that. Maybe you're collecting on behalf of a hospital, though. You got to be real careful about that. These HIPAA regulated messages are defined very narrowly, and that's because HIPAA already has regulations about when a healthcare provider like a doctor or a clinic can contact a patient. For residential lines, again, written consent for a marketer, emergency calls, non-commercial calls, or maybe it's commercial like debt collection, but they don't include an advertisement or telemarketing. Nonprofits, HIPAA calls. Okay, what about preview dialers? I know this is important to TCN and its clientele who may be using some of this innovative new technology to call cell phones, or at least call cell phones in a safer way than normal auto dialing platforms. What's a preview dialer? Well, there's a whole bunch of flavors, but generally the common theme is that they don't dial automatically or dial in mass or dial one after another on its own, etc. These are kind of one-to-one manual dialers where the call center agent, they preview or see on their screen the number and person to be called, and then they click their mouse or press a button to initiate each individual call, and then they disposition the call and do it again. Is this compliant or not? Let's talk about it. It can be if you do it right. Remember, an auto dialer includes any software which has the ability to auto dial, even if you don't use that functionality. So you can't just take your predictive dialer and say, well, we're not going to use it in predictive mode. We're just going to use preview mode to call cell phones. The dialer is still an auto dialer and can't be used to call cell phones without consent. You need an actual separate dialing platform or system that cannot auto dial even if you told it to. So a compliant preview dialer will have no present or even real future capacity to auto dial. I recommend you force the agent to either key in the entire number or in the very least make them click or push something for call-by-call individual one-to-one human intervention. There are variants on that are more or less compliant depending upon how much risk you want to accept, and of course you can make a strong argument that other flavors of preview dialers that have other functionality might still be manual. But again, the safest version of it would be one-to-one human intervention between every call. So again, you're not going to be a preview dialer most likely as long as you have no capacity to auto dial and as long as it couldn't quickly be enabled to do so. Flip the switch and now it's auto dialing. This brings in this future auto dialer capacity standard we'll talk about in a moment, which was created on July 10 this year. Okay, so how do you defeat the FCC's argument that your system might have future potential auto dialer capacity? Well, a couple of mitigation techniques are to include in your both in the software code itself and also in the contracts controls preventing modifications. If the user, for example, and maybe even the platform offerer are not allowed because of contractual restrictions to add auto dialer capacity, and if the software code itself has some built-in protocols to prevent manipulation, then you've got a real good argument, I think, that the system doesn't even have future auto dialer capacity. Again, using software to call cell phones comes with some risk. Even if it may be small, you need to mitigate that to the point where you're safe and you have a strong, defensible, compliant position. Mitigate the risks further by making sure you know which are your cell phones and which are not. Identify and or scrub. Get the developer specs on the dialer and a good legal opinion letter that it's not an auto dialer if you're going to use it to call cells without consent. Scrub for known litigators. This is kind of new. A few vendors now are offering access to litigator scrubs, meaning they can check your list against the 70 or 80 or so thousand people who have filed lawsuits before against telemarketers and see if they're on your list. You don't want to call those people even if you think you're compliant. Again, avoid campaigns, abandon calls. Multi-line again is more dangerous than one-to-one. Other new technologies, interesting, gray areas. Is this auto dialing or not? This direct drop type stuff, direct to voicemail, where it circumvents a call to the cell phone and just places a voicemail in their inbox without really causing the call to ring. Is it auto dialing or not? What about this avatar, this pre-recorded, ready response snippet type stuff? You've got a live agent, but they're listening to a couple calls at once, and they're pressing buttons on their keyboard to play little snippets. Bluetooth, social media, some of these new apps will convert a social media message into a text or vice versa. Very, very interesting technology that the law does not address. So some risk there, gray areas, might not be as safe as preview dialing, but just goes to show that technology is always ahead of the law, which causes some headaches for us. Call abandonment, I'm going to skip this because this is really for telemarketers. Wireless identification. Why should you guys, whether you're a debt collector or you're just doing customer service or confirmations for a newspaper, magazine, etc., why do you want to know which are your wireless and which are not? What's important? There are implications. Unless you have proper consent, you can't auto-dial a cell phone. And that may or may not be hard to obtain, depending upon your situation. A debt collector who bought debt can't go back in time and collect the cell phone number a different way, for example. How do you identify and scrub? Well, you use great vendors like TCN or other vendors that scrub for DNC or cell phone numbers. For wireless, you basically need to obtain and scrub against or identify two different files. One is the carrier file. This is kind of a cell phone prefix list. That's a little inaccurate, but basically it's a compiled list of all cell phone numbers or numbers initially assigned to cell phones. And then, or like kind of the wireless block list, another way to say it. Then there's also the separate cell phone list, the ported number list. You get this from brands like Newstar or Telcordia, and I believe TCN is one of the few authorized resellers of Newstar, the real big ported number vendor. So anyway, these are numbers that used to be landlines, and they were recently ported to become a cell phone number. There's this limited 15-day TCPA safe harbor. If you call a number that you thought was a landline, let's say you robocall it, you didn't have consent, but you thought it was a landline, so you thought you were okay. You dumped it in your dialer, robocalled it, or texted it, or not texted it really, but because you thought it was a landline. But it turns out, guess what? The owner had bought a cell phone the day before and ported it to the cell phone. Well, as long as you can prove you had scrubbed against the ported cell phone list within the previous 15 days, then you've got an argument for safe harbor exemption. Okay, July 10, 2015. This is the other real important thing we want to talk about here. They came out with this declaratory ruling that responded to a bunch of petitions. It was split down party lines, meaning the 2 Republican commissioners strongly dissented and the 3 Democratic commissioners voted to pass it. It's been appealed. PACE, an organization we're a member of, has filed a federal court appeal. The American Collection Association, also SiriusXM, have filed appeals. Those have all been consolidated in the D.C. Circuit Court of Appeals, but there's not going to be any relief in the near future. Most importantly, the July 10 order, and again, this is the FCC saying, this is what we think our rules really mean now. This is what we think they mean now. They rejected the argument for a current capacity standard, meaning a lot of petitions had said, look, FCC, our auto dialers should not be considered auto dialers unless they can auto dial now. This future theoretical capacity argument is BS. You should adopt a current capacity trigger only. Well, they said, no, we can envision some dialers that maybe they can't auto dial now, but they could be quickly made to auto dial and call thousands of numbers in a short period of time. We think that could be an auto dialer also. Now, they didn't go so far as to say anything with theoretical auto dialer capacity is an auto dialer. Like an old rotary phone, they specifically said, is not an auto dialer, even though in theory you could take it to MIT and they could pair it with some other devices and software and make it auto dial, etc. A rotary phone, that's theoretical capacity. But future potential, yeah. If it's merely a matter of flipping a switch or making quick, easy, inexpensive changes and it can auto dial, then it might be an auto dialer. So be very careful. If you're using kind of a preview or manual call software system, make sure that it doesn't have this future capacity that it's limited by contract and software protection so that it cannot do that. A few other changes in that order, less important but still somewhat important. The called party under the TCPA is the subscriber or customary user, not the intended recipient, meaning if debt collection floor calls intending to reach Eric Allen, but they reach Scott Allen or somebody else, or the number's been reassigned or whatever, you could be in trouble for that. It doesn't matter who you were trying to call. It matters who you call. Also, the reassigned number issue. One little break they gave us, you get one free pass. When you're calling a reassigned number, you get one free pass before they can ding you. But you need to immediately update your file and disposition it as a wrong number. Well, there is a troubling part about this. This is kind of fake protection, because what if they don't pick up that first call to the wrong number to tell you that it's wrong? Well, you could be in trouble. So work with a good vendor to make sure you're not calling on wrong numbers. Do some data hygiene, list cleanup. Also, don't call on really old numbers. Make sure you've got updated contact information. Consumers have a greater right to revoke consent now. It used to be you can condition, and I know there are separate rules that have to be in writing sometimes under the FDCPA for a debt collector, but in the TCPA, if you have this consent or implied consent to call, to auto dial a cell phone, you can't force them to write or email or call a certain number. They get to revoke that consent at any time and in any reasonable manner. That means you need to train your folks and revise your D&C policies to accept kind of an opt-out request through virtually any method. Also, the FCC clarified that carriers are allowed to offer call blocking technology. It doesn't interfere with any of their other rules. There are certain exemptions granted for banks and healthcare alerts. These don't apply to you. What are my recommendations? Before we get into Q&A, let me just say a few final things. Ensure you know whether your dialer is an auto dialer or not and what the implications are. If you don't understand that, you have massive cell phone exposure, class action exposure. Based on these July 10 changes, revisit how you identify and scrub for cell phones. Make sure you're doing it right at the right intervals, that it's accurate, that you're documenting all of this. Next, as I mentioned, revise your D&C and opt-out policies and procedures to comply with the new consent revocation rules. They get to opt out or revoke consent at any time and in any reasonable manner. Retrain your personnel in this regard to be able to take and record and make effective a revocation of consent. In my opinion, if the person says, stop calling me, then that's a revocation of consent. They don't have to say, I revoke the consent that I previously gave you, or you no longer have my consent. There are no magic words here. Treat any expression of their desire not to receive your calls as a revocation, as a best practice. Engage list hygiene vendors to scrub for wrong and reassign numbers. Require consumers and your debtors to certify that the numbers they provide are their own, and make them indemnify you and inform you if the number changes or is reassigned and they fail to tell you. Avoid calling on numbers collected years in the past. Always ask for updated contact information at every customer touch point. Consider engaging compliance counsel to audit and advise on dialer and wireless compliance. There's my plug. Stay updated as TCPA laws and regulations evolve. And finally, again, look into some of these new innovative scrubs out there. A number of vendors now offer scrubs, or you can buy them on your own. These are the telephone numbers of people who have filed TCPA and FDCPA lawsuits or class actions in the past. We don't know all their numbers, but we know a lot of them. I checked yesterday. There are about 85,000 known numbers of people who have filed in court lawsuits against call centers. You never want to call those folks, even if you think you're in compliance. And then real quick, we'll do this consent stuff in about 5 minutes. I really want to get to the Q&A quickly. But how do you get consent to auto dial? Well, you want to get the right consent, because then you can do almost anything with their permission. Again, non-marketers get this express consent when they provided the number. But I would encourage you to try and get written consent like a marketer would need to as a best practice. If you get written or recorded consent, rather just implied or verbal or something else, then you can actually prove the consent later. So I'm going to tell you a little bit about the consent that a marketer would need. But again, a debt collector gets implied consent to auto dial a cell phone when the debtor provided their number to the creditor in the normal course of business without conditions and has not opted out. Again, ideal to get written consent. Document the consent. Ensure it transfers properly if someone else is going to call. Well, here's the big, crazy TCPA definition of what written consent is. But guess what? For non-marketing calls, their little express consent, they did not define it. But not in the TCPA, but separately they said this. And again, this is for non-marketing calls. Persons who knowingly release their phone number, like to a creditor or a company, have in effect given their invitation or permission to be called at that number, which they have given, absent instructions to the contrary. That's that implied express consent for non-marketing calls. The effect is that when they give you the number, you're allowed to call them for the normal business purposes, unless they opt out or change their number, of course. Courts have upheld that, except in very, very rare cases. Now, again, if there were conditions, i.e., can I have your number? That's how we keep track of you in our file. If that's how you got their number, can't call it for other purposes. But if it was just in general, it was on a loan application or their website profile set up or whatever, then you get to call that number until they opt out or change it. Express consent, it wasn't defined in the TCPA. One big court in California said all that means is consent that's clearly and unmistakably stated. But you need to be able to prove you had consent later. How are you going to prove that? Marketers and collectors lose most of these he said, she said battles. The burden is always on the caller to prove consent. Therefore, as a best practice, I recommend you kind of pretend you were a marketer in some cases if you can, and design your language, craft it so that you have the necessary disclosures and processes and record keeping such that you can prove it later, just like a marketer would have a more rigorous type of consent. These are the elements. You can go through it with your your counsel or compliance officer later. But let me do these last two samples here so we can move on. If you might market, if you think you might want to include some marketing in the future, this is a good sample. By clicking submit, I agree to be contacted by Alan Legal, along with its agents and partners at the number I entered above, which I certify is my own number for marketing and other purposes, including the possible use of an auto dialer pre-recorded in text, and I'm not required to consent to purchase. But if you're 100% confident you'll never do any marketing, here's a better sample. By clicking apply now, I agree to be contacted by blank, along with its agents, affiliates, assignees, and debt purchasers. Very important. At the number I entered above, which I certify as my own number for collections and other account management purposes, including the possible use of an auto dialer, pre-recorded text. And I agree that this consent may be freely assigned by you to third parties, and I'll immediately update the company if my number changes. Something more along the lines of that. Again, don't just cut and paste this into your website or contract. You need something custom that works for you and your situation, or it's not going to be compliant. But that's a push in the right direction. Store your consent for at least 4 years, or 5 if you're going to be telemarketing. My final tips for real this time. We'll be doing Q&A in 30 seconds here. Make compliance a priority, both in terms of budget and corporate philosophy. If it's not a priority, you'll find trouble someday. You'll be calling me, paying bigger bucks to defend a class action, rather than something inexpensive to make sure you're compliant now. Establish your systems early on. Audit, adapt, update. This means policies, trainings, checklists, fail-safes, a compliance officer, good legal counsel, good vendors, etc. Have good record keeping. Don't just be compliant, be able to prove it. That's the other half of the battle. Resolve consumer complaints to their full satisfaction quickly. If you're generating complaints and not resolving them quickly, you're going to have investigations, fines, lawsuits. Complaints cause lawsuits, not necessarily violations. It's complaints. Do your due diligence on the people you work with. Have good contracts. Be aware of regulatory pet projects. And, of course, don't ignore state law, which might be more restrictive. There's my contact information. Of course, we're not a tech or dialer or scrub vendor, but if you have legal questions, if you need to ask something sensitive with attorney-client privilege, if you need an audit, a review, just some of our time, please reach out. We always do a short free consult. My email and telephone number are there. And I will hand Mike back over to Bryce, who has been reviewing questions for us.
Eric, thank you very much. That was very helpful, very informative. And as I mentioned before at the very beginning, if you have any questions, you haven't had an opportunity to ask them at this point, you can go into the question section there on your webinar tool, enter in the question there, or also if you're having trouble with that, you can also email me at bryce.payne, bryce.payne at TCNP3. So go ahead and jump in there if you have any questions that about what he's covered so far, or even if he hasn't touched upon it, just questions you'd like to ask him from his expertise, please jump in and ask those questions at this time. Moving over into the questions at this time, Eric. Don asks, we act on behalf of hospitals to communicate patient balances. We are looking for the wording which provides legal protection where the patient signs to authorize any calls regarding their account to the phone number provided.
That's great. I would use, Don, I would use something along the lines of the second bullet point. You might be able to shrink that a little bit. You've got some flexibility as long as, and again, as long as there's no marketing or promotional purpose whatsoever. It's just merely kind of account management for your healthcare provider clientele. As long as that's the case, I would use something along the lines of the second bullet point, except you could, if you're never going to sell the debt or hire other agencies, then you can remove all that crap about you being able to assign the debt to other people, so you could kind of shorten that. But I would start with this, create something you like that fits, whether it's a paper form or some sort of check-in form or app or something. Adapt it the best you can for the situation, and then check with your counsel to make sure it's compliant for the specific piece. The mode, the medium, the context matter. But I would start with something like the second bullet point, except as I mentioned, you can remove the stuff about you being able to assign that consent, etc. Good question.
Okay, thank you, Eric. There was a question asked as whether they can print the information that's been presented in this webinar.
Absolutely. We're going to make available the entire presentation in PDF format and possibly even the recording, is my understanding. So you will have all of this later.
Yes, absolutely. We will send out the printed version, and it's fully recorded, so we'll be sending that out, a link to that after the presentation. Let's see, next question is, since our telephone software does technically have future capacity as described in FCC ruling, when our collectors view an account and decide to dial a number, but the phone is attached to our total system, are they violating TCPA using an ATDS even though they are manually dialing?
You might be if you have no level of consent, meaning if there was no written consent, verbal consent, not even implied consent based on their providing you the number. If you have no level of consent, then yeah, you're not allowed to use a system that has even just mere potential auto dialer capacity to call a cell phone. Again, landlines are different. If half your numbers in your system are landlines, you can dump those in the predictive dialer or robocall all day. But for cell phones specifically, if you have no consent, if it's a predictive dialer and you're just kind of using it in manual mode to call cell phones, then you very well may have a cell phone problem. You either need consent or you need to use a separate manual calling system that you're sure doesn't have any ATDS functionality.
Next question is there case law supporting consent from an issuer that can be transferred to a debt buyer?
Good question. There is some, it kind of goes both ways, but this is kind of the rule. Again, if you were just calling on consignment, then you stand in the shoes of the original creditor, probably. But if for a debt buyer, that implied consent only transfers, and you'll only find at least some case law support if the number was collected in a way that made it clear that the consent could be assigned, and then the number was in fact conveyed in the documents when you bought the debt properly. So you need to look real carefully at both of those. When the number was collected, what was the language used? What was the context? And then two, when we bought the debt, did we buy that right to call, and did they have a right to convey it? If all of that is yes, then there is some supportive case law.
Okay, next question says, do you think it is safe using a predictive dialer, but turning off the messaging option so that agents are only connecting live with people who answer the phone?
If I understand your question, probably not. Assuming you don't have consent, express or implied, then you can't just restrict certain agents to using the manual part of the dialer. It needs to be a separate application. It needs to be kept separate from the auto dialer somewhat. This comes up a lot where, in fact, there was a couple of years ago, there was a huge, big ATDS case in South Florida where a call center called this woman, maybe like 4,000 times, and she won a massive multi-million-dollar verdict. It's being appealed right now. But what they were calling using a predictive dialer, but when they called her cell phone, they used the predictive dialer in manual mode only. They made sure the agents only called manually to the cell phone. The court said, you know what? Doesn't matter, don't care. The dialer itself is a predictive dialer, so I don't care what mode you may have been using at the time. You can't touch a cell phone using a predictive dialer unless you had consent. So the answer is probably no. You may have an issue there. You need to use a separate, genuinely manual type calling system for that, or obtain consent.
The next question says, can consent language validly include something that allows us to contact the customer at the number they provide then or that we get from any other source in the future?
I think yes. Some people might disagree with me, but I believe strongly that as long as you call out the specific number you can call now and you make very clear that this consent also it will be tied to any other number you give us in the future, then yes. The caveat would be if when they provide telephone number B later, if they restrict that somehow, if they say, but don't call me at this, or but this is only for record keeping, or this is only for X or Y. If they restrict it, then they've kind of canceled out that previous proactive consent. But yeah, if you do it right, and they provide the second number later without restrictions, then yes, I believe with the right language and process, absolutely, that can be compliant. Then you get to call those other numbers.
Okay, thank you, Eric. Next question. When collectors manually call landlines and have prior conversations, these will not run through your scrubbing software. What happens when those numbers are ported to cell phones?
Bryce, I'm not intimately familiar with
as
how
I read
it works
that,
with
I
the
realized
scrubbing. But maybe, this is the rule. For ported numbers, you want to be scrubbing, someone needs to be scrubbing, either you or your vendor, at least once every 15 days. That's so that you can get this safe harbor, because if you're calling, you're going to accidentally call some cell phones you thought were landline. That's because a lot of numbers get ported every day. Some people port back to a landline. That's far less likely, but there are a lot of ports every single day that ported number list goes up. And so if you call a number thinking it was landline, turns out it was a cell, as long as you can prove that someone on your behalf scrubbed the ported number list within 15 days, then you've got this safe harbor and you're fine. I've got clients that will scrub daily or in real time, but at least once every 15 days is the standard.
Well, and to speak to the TCN side of that, we subscribe to a third-party service that we update daily on those phone numbers that are, and so that company keeps up to date their files as to what numbers have been ported over. So we do that on a daily basis, so you should be covered if it's been ported over.
Excellent.
Sorry, I'm just looking through the question. Hold on one more second.
While you're looking, it's important to get this safe harbor. No one's going to take your word on it that you were scrubbing once every daily or 15 days or whatever. Somebody needs to be saving the scrub logs. You need to show the history, the scrub history, so you can prove you're scrubbing good behavior. So record keeping, again, huge part of this. Being compliant is the first half of the battle. The more important half is being able to prove it later on. Good logs, good records.
There's a string of questions that are kind of all similar in the sense of asking specifically to TCN's compliance to the TCPA with their manual-only platform. And what I'll say to kind of cover all those is, first off, we've put out an email that kind of covers our statement on that. But there's two things. First off, by contract for the manual-only platform, we dictate in that contract that you as the consumer, as the client, you do not have the ability now, nor will you have the ability in the future to manipulate that software in any way to make it become a predictive dialer. Secondary to that comment, we are working with Eric. We've discussed in thinking of additional opinion letters and things like that we can put out to aid in the concern. As we've seen, there continues to be more concern about the technology. We want to make sure you guys feel comfortable with what you're using, so we will look into some additional wording for that. But as of right now, I truly feel confident that by the wording that we have in the contract saying that the access is by that software, and that software that we give you access to in a separate login contractually does not allow you to make any modifications to that now or in the future. Okay, Eric, that actually covered a string of ones. I was stringing through him. There is a question. It says, is the 15-day safe harbor in the declaratory ruling?
It is not. It is, I believe, and I've got Scott, one of my law partners here, I believe it is in the TCPA statute. I'm sorry, not the statute itself, but in the regulations, which are also considered law. So it's not in the report and order. This wasn't in July 10. This is in the regs. They're part of the CFRs, or the Code of Federal Regulations. They're treated like a statute, like law. They were authored by the FCC. So it's as if it were in the TCPA statute itself, but it's actually in the regulations promulgated by the FCC with the authority of Congress for them to do so. So no, it's not in the report and order or any of these declaratory rulings. It's in the actual administrative regulations that are in the Code of Federal Regulations now. And if you want to cite, if there's any counsel on the phone, you're looking at CFR 47, subsection 64.1200. That's 47, 64.1200 for that safe harbor.
Okay, this question would be more to me. It says, does the current TCN platform have a main and manual mode so an agent can switch between both? Is the TCN main and manual platform completely different applications? So yeah, we have a full predictive dialer software, and we also have a manual only platform. In our efforts to comply with what we interpret the TCPA rules are, we establish a completely separate software, separate login that it does not have the capabilities, does not have the predictive dialer capabilities within that software, and you do not have the ability to modify it in any way, and it won't have that ability in the future. So we feel that as we've consulted, that gives that level of separation that is necessary to meet with the compliance.
Also, one comment there. You know, we may have a lot more clarity here in a year or two when the federal courts respond to the 3 appeals which have been filed against the FCC on this issue. Those have been consolidated in the D.C. Circuit Court of Appeals in Washington, D.C., and those are working their way through that process now. It's possible we may find some relief from at least some of these rules in the future, but it's not going to be tomorrow or this year, maybe not even next year, but we're hoping to see some changes, or possibly also something from our our legislature. We encourage all of you to reach out to your representatives, encourage them to revisit the TCPA. They just don't, politicians don't understand call centers. They don't understand dialers. They don't understand a lot of this stuff. Yet they're making the rules that affect whether you and I can pay our bills in this industry. So it's important to be vocal about these issues, explain your frustration, not just to those in the industry, but to politicians who don't know anything about call centers or debt collection or telemarketing.
Well, and I'd like to add as well, Eric, as we were talking, there's something that I think is important as we talked yesterday. More and more people are adding into the people issuing credit are adding into the contracts express language that says that by accepting this debt, you give express written consent to call you in the event of a default, which I think we might see that very shortly here. All of these things become null and void, all these concerns, because these people will have given their express written consent at the point of issuing the debt.
Yeah,
and I think
great,
that'll make
great
a big
point. I mean, ideally, you're going to have consent to do whatever you want ahead of time. That's the goal, is to have a big, callable consent database, whether you're a marketer or a customer service call center or a collections agency. The goal is to always be able to call with prior consent obtained properly with the right disclosures and record keeping. And then you don't care whether it's a cell phone or not. And you don't care whether you're using an auto dialer or not. If you have consent, you get to do it.
Well, I really appreciate your time, Eric, and I hope we've been able to answer everyone's questions. There are a few, if we have not been able to get them, we will follow up with the emails to those people that have asked questions we haven't been able to get to at this time. If you think of things after the presentation is done, please don't hesitate to reach out to either one of us with the additional questions. We're here to try to make sure that we can meet your needs and to make you feel confident in what you're doing as a business. I appreciate everyone joining us today and appreciate your time, and we look forward to next month as we continue with the webinars. Thank you very much.
Thanks, Brian.